So who are you going to give everything to when you die? And you cut that person out too? It's going to cause a fight. Who did you put in charge? Wow, your son's not going to like that. Oh, who am I? Well, I'm just a nosy neighbor. After all, if you're going to pass your house down to someone, I'd like to know who it is. And what gives me that right? Well, you died. I get to know everything, even if I'm not a beneficiary. It's all a public record. Well, hello, Attorney Andrew Bethel, and that weird interaction, while hyperbolic, does speak to an underlying theme of what I talk about but don't always highlight specifically, and that's privacy. Today, we'll talk about what the public gets to know about your estate and whether your living trust needs to be recorded. Be sure to hit the like button to let me know you enjoyed the video or learned something. Be sure to subscribe and share the video with your kids, and let's jump into it. Right off the bat, let's answer the question, are living trusts recorded in California? No. But you know that because we're in a legal field, that's not the whole story. However, we'll get into that in just a moment. First, let's discuss why a living trust is private in the first place. A living trust is private in the first place due to the fact that so long as you have a living trust and you've titled your assets into it, your estate will avoid probate court upon your passing. I've talked about why this is the case many times on this channel, but to summarize it here, your trust owns the property with you in charge as trustee. When you die, the trust continues to own the property, but immediately empowers someone to take over management of that property, the successor trustee. And because that person will have authority almost automatically, they just need a death certificate, there's no need to go to a probate court to get a judge's order to grant someone authority to manage the assets of a deceased person. Due to this, we're not filing the trust in the probate court, and we get to handle everything around the kitchen table, or the lawyer's conference room if you choose to get me involved. However, I did tease you with the fact that a simple no is not the whole story. Now that we've established that a trust is private, let's discuss what aspects of it are public. Deeds for real property. If you'll recall from my video on what is a living trust, when you're creating your trust, you need to move your real estate to your trust. This is called funding. In order to fund your trust with real estate, we do the same thing we would do in any other circumstance with real estate. We record a deed with the county recorder's office. Now, we're not recording the trust, only the deed transferring the property from you as an individual to you as trustee of your trust. In order to do so, we would, of course, need to indicate the name of your trust on that deed. All deeds must have the grantee identified, the person receiving the property, and since the trust is receiving the property, you have to put the trust name down. However, that's it. There's no filing a copy of the trust, no need to identify who the successor trustee is, no exhibit listing the names and addresses of the beneficiaries like a certain other state to our east requires to be done. No, the only thing to be listed on that deed transferring the property to your trust is who the current trustee is and what the name of the trust is. That's all. Going further, there are ways to obfuscate even these details if anonymity is a concern by having a more generic trust name and a nominee trustee. I've touched on this topic in my video about land trusts versus LLCs for California real estate investing, so I'll link to that in the corner. But be sure you're subscribed because I do have a video in the works where we'll explore that concept in its own deep dive. Next, we have one more case where there is something public, and it might sound strange, so bear with me, your last will and testament. California Probate Code Section 8200 subsection A requires that whoever is holding the last will and testament of a deceased person deliver that will to the clerk of the Superior Court and the named executor. Delivering the will to the court is called lodging the will, and doing so technically makes that last will and testament a public document. And the kicker is, this rule applies whether there's going to be probate or not. From experience, if there is not going to be a probate, most folks don't bother with lodging the will with the court. This is the case when the decedent's estate either doesn't meet the probate thresholds or where they have a trust that's going to manage everything. However, that does bring us to the second case where we have an aspect of the trust becoming public, but it's similar to recording a transfer deed in that the only public fact would be the name of the trust. And I suppose the fact that there is a trust in the first place. This is because if someone has a trust, then they likely have a pour-over will, which is not going to lay out the distribution in terms of their trust, but merely states that any property in their personal estate is to be distributed to their trust and indicate the trust name itself. Watch our video on pour-over wills for some more details on how they work. But with that, that's it. No, your living trust does not have to be recorded anywhere. It is a private document by its nature. There are two cases where at least the trust name is public, the deed when transferring real estate to the trust, and when a pour-over will is lodged with the probate court after the trust owner dies. The moral of the story is, create a trust, avoid the nosy neighbor, and keep the family drama private. But this is where I leave it off to you. Have any questions for me? Have a topic you want me to cover? Let me know in the comments below. As always, don't forget to like, share, and subscribe to learn how to protect your estate from prying eyes. I'm attorney Andrew Bethel, and I'll see you at our next meeting.